meeting, all persons having business with the appellate division are here, give your attendance, and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division First Department. We have 8 hours of argument time requested, and all of us want to start getting ready for Thanksgiving. So only ask for the time that you need, not the time that you want. If we have more questions, we will keep asking them, and we are familiar with the briefs and records. People versus Garner-Lowry. It looks like, oh, are you here? 4, 1, and 4. 231, 249 West 39th versus Chan. Respondent? 6, 1, and 5. M.A. Children is submitted. 25th Street multifamily versus 208, 214 East 25th.
Jonathan Morgan for defendants Appellate, 5 and 2. Respondents,
5, 1, and 5. Ward versus City of New York is submitted. People versus McMorris is submitted. People versus Davis.
Appellant requests 5 and 2.
Respondent? 5, 1, and 5. AC Penguin versus 2015 appellant. I'm sorry, what'd you ask for?
4 and 3.
Respondent?
Respondent requests 5.
4, 3, and 5. Stoller versus City of New York? Submitted. Cornelius versus Moody's Investors appellant?
Good afternoon. Appellant requests 6 and 2.
Respondent?
5, Your Honor.
6, 1, and 5. Golden Nugget versus Chan appellant? Respondent?
4 minutes, Your Honor.
5, 2, and 4. People versus Martinez is submitted. Paley versus Curious Holdings, appellant?
Appellant, 5 3.
Respondent?
5. Thank you.
5, 2, and 5. New York Marine and General versus Cookman Best Insurance, appellant?
Good afternoon, Honor. Kathleen Dillon, request 5 and 1.
Respondent? 5, 1, and 5. People versus Aponte is submitted. Donaldson versus Port Authority, appellant?
Good afternoon. Appellant requests 5 and 2.
Respondent?
Good afternoon, 5 minutes, please.
5, 2, and 5. SR versus Erle, appellant? Respondent? 5, 1, and 5. Malkowitz versus Acquisition America, appellant? Respondent?
4 minutes, Your Honor.
5, 2, and 4. People versus Hatton is submitted. People versus Jefferson is submitted. And Board of Managers versus 141 East 88th Street is submitted. So our first case for argument would be People versus Garner-Lowry.
Good afternoon, Your Honors. Isabel Patkovsky of the Legal Aid Society for Yael Garner-Lowry, who goes by Mr. Gardner. This offense, Mr. Gardner's first ever, occurred when he was 19 years old, had just become unhoused, and was living without family in the shelter system. Because there was no...
You're arguing your excessive sentence aspect of the...
Yes, that's the only argument, Your
Didn't
Honor.
he already receive the minimum jail term in this matter?
He did. He received 5 years.
So why should we tinker with the PRS at this point? Since it was clear from the colloquy that 3.5 was a compromise between the parties that was negotiated.
Yes, Your Honor. 2
not
points.
the maximum.
No, he certainly didn't receive the maximum, but he did receive more than the minimum. And I think
Wasn't that negotiated between the parties, that since the people were asking for the maximum and he was asking for the minimum?
it was negotiated between the parties, but the Court of Appeals has held that because the power disparity in plea bargaining is so great, the fact that a disposition is negotiated is far from dispositive. I would submit.
So in this case, at the time of sentencing, was there a significant criminal history that your client had?
I'm sorry, could you repeat?
Did your client have a significant criminal history at the time of sentencing?
He had none, Your Honor. This was his first offense.
There were no arrests before that?
Subsequent to this offense, yes. But this was the first one.
Was it subsequent to this offense, but prior to sentencing?
I think that's right. There were some arrests.
Okay.
He hadn't yet been.
So that's what I asked, at the time of sentencing.
I'm sorry. Yes, there were
So
arrests.
six
along with
arrests,
sentence.
so 6 arrests, right? And was one of them including a possession of a loaded weapon?
Yes, he was sentenced concurrently on that. Following.
So given this significant history, why is this sentence inappropriate?
Because what's so notable about the history is that he had no interactions with the criminal system or the juvenile system prior to this time in his life when he was a teenager and suddenly became unhoused and was living in the shelter system alone. And
But isn't that an argument for why the supervision inherent in PRS would be helpful to him at this point where he seems to have had a change in functionality, and it might actually be very helpful to him to have PRS at that point?
I think that, as we argue in the briefs, that studies have demonstrated quite conclusively that post-release supervision really stops being helpful after the first year or so. It is helpful at first when people are first coming home. That's often a difficult transition. But for longer than that, it can actually impede reintegration because it's simply one more burden on a person who's already navigating lots
And
of
do those studies distinguish between the general population and someone like defendant who had a clean record and all of a sudden had 6 interactions with the criminal justice system? Wouldn't that be a different situation that might deserve separate study?
I think that's a fair point. I would say that all of these arrests came on the back of him becoming involved in the criminal justice system. When he was sent to Rikers,
But there are no studies about how somebody in that circumstance is affected by PRS.
No, although there are studies showing that the detention of young people can actually make it harder for them to subsequently reintegrate. For example, when Mr. Gardner went to Rikers, he was assaulted in his first night, which I think is just a show of how young, how vulnerable he was. The facts in this case are certainly not, it's a terrible thing that happened. But I think the record pretty clearly indicates that this was a boy who was going through an unimaginably traumatic situation. And not only this court, but the Supreme Court.
Well, here's the thing, counsel, because I think it's been highlighted by my colleagues that the 6 arrests came at the time, before the time he was sentenced, which is something that the court was aware of at the time of sentence, and this was what his sentence was. Again, less than the maximum for PRS.
Respectfully, I think those other arrests should be resolved on their own merits. All the court had before it was what Mr. Gardner pled to in this case.
He was out on bail, right? No, fine. Just go ahead. Don't worry. I'll ask
You have time on rebuttal. Thank you. I didn't mean to.
No, it's all right. The light was on.
Good afternoon. May it please the court. Margaret Crookston for the people. Defendant received an incredibly favorable sentence, and his period of post-release supervision should not be reduced.
Speak up a little.
Oh, I'm sorry. My apologies, Your Honor. This was an incredibly violent crime, and as noted, defendant was subsequently arrested 6 times during the pendency of this case, including and was charged with a violent felony in the Bronx, which he was able to serve the sentence for concurrently. At the same time that he pled guilty in this case, he also pled guilty to another pettit larceny charge. So the court was aware of his continuing criminality throughout the pendency of this case.
Wasn't he facing 25 years or potentially 40 years if they were running concurrently? I mean, consecutively?
Yes, that is true. He was charged with 3 violent felonies for this particular incident. It was first-degree assault, first-degree gang assault, and then the second, Good Samaritan, it was attempted assault. So overall, he was facing up to 40 years on this case alone, and however, because of his situation and all the mitigating factors that defendant now raises, the court was willing to give him the minimum sentence of incarceration and 1 year above the minimum of post-release supervision. For these reasons, we ask that you affirm. If there are no questions, thank you.
Thank you very much.
Very briefly, I just want to emphasize 2 points. First, that 5 years is a significant amount of time in a 19-year-old's life. And I don't want to be, again, minimizing this offense, but I think it's important to remember that 5 years is a very serious sentence for someone who had no criminal history and
They
was
got
still
the
a child.
minimum sentence.
Yes.
What's the minimum sentence?
That's correct. But they could have offered him a plea to a lower, I mean, there were other things that could have happened, and they offered him 5 years in the end. Second, I think what the government has failed to do in its response, and as well as here, is engage with our argument about why post-release supervision can actually be harmful. And that's really important in Mr. Garner-Lowry's case. I take your point, Your Honor. I don't have statistics talking specifically about 19-year-olds with a lack of criminal history, but what the Pew report did show quite conclusively is that long periods of post-release supervision make it harder for people to do things like go to therapy, go to work, go to school, or simply be a responsible family member. Thank you.
231, 249 West 39th versus Chan.
Good afternoon. May it please the court, Yvette Sutton, Lazarus and Lazarus PC, on behalf of the appellant Sherman Chan. This is a rather simple issue that's before the court, one that has been determined by this court previously in cases similar to this in Loho LLC versus Batista and 404 Park Partners LP versus Lerner. And that is a question of whether a guarantor is liable for use and occupancy charges after the lease is terminated or expires. The answer...
I'm not sure what the basis for your argument is that the lease was terminated or expired during the period for which the landlord is seeking to recover rent. What's the basis for that statement? I mean, it was not expired by its terms, obviously, and the tenant had not vacated the premises, so why was it expired?
There's clear language in 2 stipulations that the parties, not the appellant, but the landlord and tenant, signed, one dated April 2018 and the other dated June 2019.
Go ahead.
But then they renegotiated that and reinstated the lease and extended it so that he wasn't held responsible until after the tenant had vacated, and he was only held liable for the amount due through the date when the tenant vacated. So I'm having trouble understanding your argument in the context of the actual documents in this case and the unusual history of the leases being negotiated and then extended and renegotiated and so on.
Yes, very clearly at page 91 as well as at page 100, both stipulations say that the lease is only reinstated upon full compliance with the stipulations that were entered. And there is no issue of fact that there was never full compliance with the stipulations.
But they renegotiated after that point so that the lease wasn't in fact terminated until the vacator, I've forgotten the date, when the vacator finally occurred.
While there may have been some outside negotiations, the documents very clearly state that there's...
in this case as to when the tenant actually vacated the premises, right? I mean, we know the date that the tenant vacated the premises, so what is your argument as to why there shouldn't be a full guarantee up until the date that the tenant actually vacated the premises pursuant to the warrant being executed?
Well, the appellant, the guarantor, only guaranteed the amounts due under the lease.
But he said that he would guarantee all amounts due while the tenant was in possession, and there doesn't seem to be any dispute in this case as to when or what date the tenant was in possession until.
there are two other instances in the guarantee that specifically limit the amounts due by the guarantor through to due under the lease. So it has that language that prefaces that it's only amounts due under the lease. And given that the lease was terminated and never reinstated by any agreement between the parties,
But how could the amounts not be due under the lease if the tenant was still occupying the lease?
well, based on the stipulations, the amounts do increase because not only was the appellant paying the rent, but it was also paying amounts that were agreed upon per the stipulations. So, and it's not very clear that the guarantor agreed to those amounts. He's not a signatory to any of the stipulations between the parties from landlord-tenant court. And unless there's express language that shows that a guarantor is liable for amounts due, then the guarantee should be construed in appellant's favor.
Thank you.
Thank you.
Excuse me, good afternoon, Your Honors. Thomas Kleinberger, Thomas R. Kleinberger, PLLC, for the respondent.
Counsel, did the stipulations change the terms of the lease?
It did not. I mean, like, in a sense, I mean, this,
Counsel, how do you respond to the termination argument?
so I think the language in the stipulations was what I would call slightly imprecise. By the warrant issuing, the landlord-tenant relationship was kind of severed, or because it's in the context of a stipulation and there's a reinstatement provision and they actually had the right to remain in there through the end of the term of the lease, I would say it was suspended. But even if it was terminated, the termination of the landlord-tenant relationship does not terminate the tenant's obligation under the lease to pay all of the rent reserved under that lease. And it also doesn't terminate the guarantor's obligation to pay all of that rent up until the time that the tenant vacates. So,
Is there anything being sought in this case over and above the rent that was due under the lease?
no. I mean, simple answer, no. I mean, in fact, there was a large waiver of rent earlier on, and the security deposit was applied to substantially the period of time that the tenant was actually in possession. So,
Was there a holdover period in this case? Was there a holdover period?
no. The term of the lease expired, I think, in 2021, I believe December 2021, and the tenant was evicted in 2019. And, and very briefly, just to the cases that are cited by appellant, in each one of those cases, the tenant and the landlord entered into an extension or a new lease, and they tried to hold the guarantor of the earlier lease responsible, and the court said no, understandably. That is not our situation. The lease that this guarantor guaranteed, the financial obligation remained in full force and effect, and the tenant remained in place until, I believe, September 2019, and Justice Bannon, granted a judgment in the landlord's favor up to the point when the tenant was evicted by the marshal. So we believe Justice Bannon got it right. We believe this court should uphold Justice Bannon's decision and deny the appeal. Thank you, Judge. It is.
Thank you. Very briefly, at page 90 of the record, it shows that respondents shall pay the sum of $140,000 a settlement amount to petitioner in 18 monthly installments of $7,777.77, which was essentially additional rent over and above that which the tenant was required to pay under the lease. It increased the monthly rent by $8,000, and there's no saying that the guarantee, which should be strictly construed in favor of a private guarantor and cannot be altered without the guarantor's consent, should show that here the appellant, the guarantor, okayed those amounts. He did not sign any of the stipulations. And just one other quick point, the security deposit, as is stated in the lease, should be applied to amounts due under the lease and not for amounts for use in occupancy.
Thank you very much.
Thank you very much.
25th Street multifamily versus 208, 214 East 25th Street.
Good afternoon. May it please the court. Jonathan Gordon with Ovid and Ovid for defendants appellants 208 to 214 East 25th Street LLC and Stephen Croman. This is an appeal from a June 2024 amended judgment of foreclosure and sale and an underlying July 2023 decision in order granting respondents' motion for summary judgment on the cause of action for foreclosure and striking appellant's answer
Can
in
you
affirmative
address,
defenses.
the primary question is, for me, is your claim or your assertion that there was a good faith mistake here. So could you address that specifically, why we should accept your argument that there was a good faith mistake, especially where there was an attempt to maybe make a partial cure after the acceleration?
Certainly, Your Honor. So if you look at the affidavit of Stephen Croman, who's the principal of the borrower, what he says is that, you know, this borrower had a 5-year perfect payment history. There's another entity that is responsible for managing the borrower's affairs, and somebody at that entity was responsible for ensuring that this account was sufficiently funded such that it could be auto-debited on the payment date. Due to internal staffing issues during COVID, with people at home and people laid off, and a transition of the CFO, there was confusion as to who had responsibility for.
Granted, but in June of 21, you get a notice advising you that there was or advising your client that there was a missed payment, correct?
Well, so no, Your Honor, I think there's a dispute as to that, right? So in Mr. Croman's affidavit, what he says is that borrower first learned of the fact that this account was insufficiently funded when it got the August 11th, 2023.
No, are you claiming that no notice was sent, or that Mr. Croman did not receive them?
I'm claiming that borrower did not have notice. And here's the thing, Your Honor.
The
borrower did not have
the borrower's account that was insufficient, correct?
Correct. And borrower did not have notice.
That his account was insufficient?
Well, so this is an account that, you know, has payments coming through it and taken out of it, auto-debited, and borrower was unaware that the account was insufficiently funded for the auto-debit to occur. It's not like there was a debit, you know, and it appeared and it bounced or whatever. They simply didn't debit it because there weren't sufficient funds there on the payment date. There were funds, but not enough for the full payment, so they didn't debit it at all, and borrower did not realize that that had occurred. With respect to the notice that they claim to have sent in June, it's very important, Your Honor, to look at the consolidated mortgage. If you look at Section 11 of the consolidated mortgage, it specifies how notice is to be given. It says that notice has to be in writing and is deemed given 5 days after it's postmarked, and it's supposed to be sent to 632 Broadway. The June email was obviously not a written notice that was sent to that address. None of the account statements or installment statements were sent to that address.
I see that's a technical argument, which I accept, but we're talking about your client's good faith.
Right.
And so the question is are they on notice back in June that there's a problem?
And they weren't, and at a minimum, it's an issue of fact. Mr. Croman says that they didn't have notice. The notice certainly wasn't sent to the right address. They claimed to have sent various notices, but when they sent that August 11th, 2021 default and acceleration notice, they did send it to the address that they were supposed to send it to in the consolidated mortgage. When they sent the notice of assignment, they sent it to the correct address that the notice provision requires. When they sent, you know, the rejection of the cure payments, they sent it to that correct address. So when they wanted to send, you know, notices to the correct address, the one that's specified in Section 11 of the consolidated mortgage, they certainly knew how to do it, but they chose not to do it. You know, furthermore, but you then have that.
That could have been a good faith mistake?
What?
That wasn't a good faith mistake?
What wasn't a good faith?
The fact that they mailed it to the wrong address?
We're not talking about, I mean, even if it was a good faith mistake, the point is that my client made a good faith mistake. My client inadvertently did not sufficiently fund that account. The borrower had money.
For how many months did your client inadvertently not sufficiently fund that account?
It was June, July, and August. However, the June payment was debited in full at the beginning of August, and half of the July payment was also debited at the beginning of August. So when the mortgage was accelerated, all that was missing was half of, or part of the July payment and the August payment. The July payment was
So his
due.
good faith mistake was in not noticing what was in his own accounts and whether or not it was enough to pay his debts, right?
Well, so
His obligations.
it inadvertently was insufficiently funded.
I mean, what does that mean? Inadvertently insufficient funds in your account where you have an account where you're paying these operating costs or these costs, and it's insufficient 3 months in a row. At what point does that not become bad faith and just now ignoring your debts?
Because as soon as we knew about the default, as soon as we learned, that there had been this confusion.
So you
And,
didn't even pay the full amount at the end.
well,
When
so,
you
so,
became current, it still wasn't the
well,
full
so
amount was due.
that's not quite true yet.
Well, I'm going to let you respond to that on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the court. I represent the plaintiff respondent. First of all, to address Your Honor's point, no notice is required under the loan documents in connection with a payment default. That's a typical term in every commercial loan, which this was. In any event, the borrower did miss the June installment, and the lender did not just sit back and watch this borrower default. We gave the notice of default on June 30, as you acknowledged.
How did you give notice?
We sent a courtesy email to the borrower's property manager on June 30th. We said, you're in default. Please pay your June installment. And what the borrower did then.
Respond?
I'm sorry?
How did the property manager respond?
The property manager did not respond until August 4th. August 4th is another email where they acknowledge that on August 3rd, there was a sweep of the account, which accounted for the June installment that was missed. So on August 4th, there were email communications between the borrower and the lender. The borrower was inquiring, hey, did you sweep the account for June? And the lender said, yes, that was for the June installment. So what happened next was the borrower then missed the July installment, and then the borrower missed the August installment. And that's when the loan was accelerated.
And once it's accelerated, you are under no obligation to take less than the full amount. Is that right?
Acceleration, that's correct. And the payment that came later in September 21st, came 73 days after the July installment was missed, 42 days after the August installment was missed,
And was
39 days.
Was it full payment?
No, the borrower was short, assuming that the loan was not even accelerated.
That's what I mean. Even if it wasn't accelerated, it was still short.
Was short by $250,000 because that accounted for the July installment, the August installment, and now the September installment that would have been due on September 10. He delivered the checks on or about September 21st, so they were short by $250,000. So this is not a de minimis default at all, as the borrower seems to suggest. The borrower waited and didn't attempt to fully cure at all. And that's what actually Justice Kahn held. He said, waiting approximately 30 days is just simply too long, and it's actually 6 weeks since the loan was accelerated. The Judge Kahn also found that the allegation that the lender acted entirely in bad faith in accelerating the debt was entirely belied by the established facts. And nor can this borrower claim that he was subject to some kind of forfeiture, because, as they did in their briefs, the cases the borrower cites are essentially landlord-tenant cases where a lease was terminated. But the borrower here always had its equitable right of redemption. And instead of exercising that equitable right of redemption, because they still own the property, their rights of ownership did not terminate, they instead opted to litigate with us for the last 3.5 years in the lower court, a couple times on appeal in this court, in the bankruptcy court where their case was dismissed as a bad faith filing, and then again in the Southern District of New York in connection with the appeal of that order dismissing the case. They could have taken steps to redeem the debt, but they didn't. And what happened ultimately just 2 weeks ago, and Judge, you're probably familiar with this because there was an application for a stay pending appeal.
That's not part of this record.
No, it's not, but I'm just letting you know that the foreclosure did in fact take place. This is not one of those rare cases, as the cases say, where equity could possibly intervene in curing their defaults.
Thank you.
Thank you, Your Honor.
So, Your Honors, a few points on rebuttal. You know, first of all, so the lower court conflated the case law. The lower court confused what the legal standard is for the defense of unconscionability with the defense of tender of payment. The case law is clear that the defense of unconscionability is available even after acceleration and in order to prevent acceleration. So whereas here, somebody
I could see if it was a hyper-technical day or two default and then an acceleration, but that's not what occurred here. Your client seems to me either knew or should have known what was in his account and moved much more expeditiously than he did.
So again, you know, respectfully, Your Honor, that's not the standard. It's not what they knew or should have known. It's what they knew.
Well, we're talking about good faith.
But the standard is according to.
But your property manager got an email.
I don't know if they did or didn't, and that's why there's an issue of fact and we need discovery, right? So there's no evidence that email was received. That email was never responded to.
Is the property manager still working for you?
I don't know, Your Honor. That those facts aren't in the record. But furthermore,
Thank you. Thank you very much. People versus Davis. Thank you.
Nyla Siddiqui for Appellant Celeste Davis. Ms. Davis's plea was not knowing or intelligent because the court failed to inform her of the accurate sentencing parameters, and it was involuntary because the court's statement that an otherwise lawful sentence was, quote, off the table was an explicit threat to a heavier sentence should she proceed to trial. At the time of the plea, Ms. Davis was a 59-year-old woman with no prior criminal history and was grappling with significant health issues.
Why didn't she move to withdraw the plea?
She didn't formally move to withdraw the plea, but she did in her statement at sentencing in the PSR note that she was not the initial aggressor, that she's only doing this.
She never moved to withdraw or to vacate the plea.
So she's actually not required to, given the fact that she did not know that this was a basis for her to withdraw the plea. The court.
What about vacating it once she entered into the plea? What about making a motion to vacate as opposed to reserving the issue for appeal?
Well, because the court had essentially told her, and she was under the assumption by the court's coercion and improper advice that this was the best offer she was going to get. Should she go to trial, it would be more jail time, up to 7 years.
Well,
and that's
hold
simply
on.
not true.
It was a D felony?
It was a D felony.
And the exposure was incorrect?
Yeah, well, so the exposure with mitigation was she could have gotten 5 years probation.
But but what would be the maximum?
7 years.
So the exposure is 7 years?
But yeah,
yes?
Yes, that is
okay.
correct.
And so then at the sentencing, when the issue of the PSR, was that she raised some kind of justification defense, was that addressed at sentencing?
That was, however, at the time she took.
And when it was addressed at sentencing, what did the court inform her to, or did the defense counsel confirm that they discussed the statements of probation with her, and then the defendant confirmed that she was admitting the intentional acts?
So that did happen. However, what is at issue here is at the time she took the plea, whether or not she was properly informed of the full sentencing parameters, which includes both the minimum and the maximum. And what is instructive here is this court's decision in People versus Johnson, where you had a youthful offender who was advised that she would get sentenced on a robbery the sentencing range was between 5 and 25, and that was actually incorrect when the sentencing exposure was 3.5 to 10.
Yeah, but but that's a different sentencing parameter. I agree with you, but we're not disputing the fact that on a D felony, the maximum is 7 years, and that's what the court told her.
No, but what we're disputing here is whether or not after trial, before another judge, she could have gotten a day of jail and probation.
But the court was just telling her the maximum. A court's required to explain the maximum exposure.
Yeah, but what the court did do was not explain the full sentencing parameters, which includes the maximum and the minimum. Yes, she said it's 7, but she also said that should she get sent to trial to another judge, no judge could give her less than a 30-day 5-year probation split. And that is simply incorrect because the judge who's presiding over the hearing, presiding over the trial, could have sentenced her to a shorter sentence. And so she was basically promised by the judge more than 30 days jail, maybe a state prison sentence, when that's simply not accurate.
The court indicated that it would take a 6-month split, though, right?
I'm sorry?
Didn't the court say that they would consider a 6-month split, but open to less jail time? I mean, they went through the court. There was a whole colloquy before it actually got to that. This is what the maximum exposure was.
So the issue is not the maximum exposure, and that's correct. There is the quality.
So you're telling me that any time a court takes the plea, the court has to now say, you can get probation, you can get community service, you can get, some kind of alternative resolution, you can get this maximum exposure. And if you go to another judge, I don't know what they're going to do, but let me tell you what they can't. Is that what you're saying?
No, that is not what I'm saying. I'm saying that the law simply requires that the court inform the defendant of the correct, accurate sentencing parameters, which what is commonly said is anything can happen at trial. You could get probation after trial, or you can get a maximum of 7 years.
What does that mean, what's commonly said?
Yeah, well,
what's that mean?
What's clear in the record is that the judge did not know what a lawful sentence was when she said to the defense attorney, that is not a legal sentence, that is not a legal sentence, looks at a subsection of the penal law that does not tell you what a legal sentence is. So the court herself was not aware of.
Thank you. You have time to rebuttal.
Thank you.
Thank you, Your Honors, and may it please the court, Addison Esley for the people.
What's your response to that the court didn't fairly advise her as to what the range of sentence was?
Everything Justice Bybin told the defendant below was perfectly informative. She gave her the correct maximum, and as Your Honor pointed out, they went back and forth on this colloquy to get below that 2-year minimum that an assault to would otherwise.
Did the court threaten the defendant with the maximum sentence?
No. The court said, I'm sorry?
Was everything accurate that the court informed the defendant?
Yes. There are no further questions, Your Honor. The people ask that you affirm the conviction.
Thank you.
Very briefly, it's not just that the court did not threaten her with the maximum. The court threatened her with more time, which the threat of a heavier sentence is what courts have found to be unduly coercive.
I guess I don't see it because you acknowledge that the upper level was an accurate statement. So I don't see why.
On page 4 of the colloquy, the court says to the defendants, once sent out for hearing and trial, this is not the offer. That offer is off the table, and once sent out for hearing and trial, and if convicted, the exposure is up to 7 years. This is
But the court
basically.
didn't say, I'm going to give you 7 years.
No, she didn't say that.
That would be a
but
threat.
what she did convey to a 59-year-old woman with significant health issues who's had no contact with the criminal justice system, that she was basically guaranteed more than 30 days jail, which was the best offer that she was going to get. And that is what when looking at whether or not it was knowing and voluntary, it's how it was received to the defendant.
Thank you. AC Penguin versus 2015.
Good afternoon, Your Honors, if it pleases the court. This appeal is pretty straightforward. A debtor's contractual interest is subject to turnover. That's been clear from.
So this was an interesting, this was an interesting lesson in CPLR and judgment enforcement, but just looking at the face of the statute, the reason there seems to be an A and a B is A talks about when the judgment debtor is in possession of the property, and B talks about when the property is not in the possession of the judgment debtor. And although you seem to make a lot of arguments, the property we're talking about is the proceeds of the separation agreement, and that, I don't know how, no matter what argument you make or how you try to twist it, I don't know how you can argue that that property is in the possession of the judgment debtor. Whatever holding we ultimately came with, she doesn't have the property. The judgment creditor has the property.
What she has is a contractual interest, which I appreciate the court hears me, but it's not like I'm making that up as a new concept. In fact, I think even before Judge Singh in Verizon versus Telecom, before you were in the appellate division, the same argument was made. A contractual interest is subject to turnover. I mean, the most obvious example of that of all is in APCO, not to mention, I think we identify at least 4 other cases where that happens. A contractual interest is an asset. It is separate completely from the money. That's what happened in Griffin, in APCO.
So what does that mean? So let's say you're right. What does that mean? It's contractual interest, so you're saying that that she can then demand the monies from the other side? I mean, how does it work? How do you enforce that contractual interest?
The contractual interest is assigned. That is.
How do you enforce it?
How do I enforce it?
Yeah.
Well, in this case, the third party said they would honor the assignment.
So you would then make a demand on the third party?
I would say I am now the.
So the court would have to issue an order with respect to the
court would not have to, because I'm stepping into her shoes. My client steps into her shoes, and they're demanding the money just as she would if not for the restraint.
But they have already indicated they want a court order ordering them to turn over the property before they turn over the property.
They said they wanted either a court order or an agreement between the parties. An assignment from her would constitute an agreement between the parties.
Then how could we, as a court, have the power to
yes, in theory,
force the order where she doesn't have the property? You're only going to get the property if it's turned over by someone who's in possession of it, which is not
yes, if the third party refuses to honor its contractual obligation, which is like any other contractual obligation, I would then, of course, have to go ahead and sue them.
Why don't you just do it the way it says and sue them now as the person in possession? This seems very convoluted.
There are a lot of reasons. And more importantly, there are instances where one way or the other way are the only option. If if either the debtor or the third party are not in New York State, it wouldn't be subject to the jurisdiction of the court, and one would have to. To deny my client the ability to do this would severely limit the ability of other creditors to go ahead and pursue when the third party is out of state. That's the point of all of these cases. That's the point of APCO, that's the point of Kohler, that's the point of Hotel 71, to overturn us on this, to not allow my client to take a contractual interest would be undermining case law that the Court of Appeals not only made, but then referred to itself as seminal.
Well, let me just see if I understand. You're not really focusing on the fact that you want us to force the possessor of the company, the possessor of the
correct. No relief is sought.
You want us to order her to assign it to you.
That is it. Correct.
And what provision of CPLR would allow that? You're saying
5225A and 5201. 5201 identifies a contractual interest as an asset that's subject to turnover as detailed in APCO. 5225A says you can specifically use the word interest, and it says you can do that by motion against the debtor.
Thank you. You have time, rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the Court, Michael Lyonoff for the respondent. The appellant here cites ABCO an awful lot. The issue in ABCO is not analogous to the one here. That was a case involving a party's interest in film distribution rights. The money in that case hadn't yet manifested. The money didn't exist. It wasn't sitting in an account. It was monies to be created by how much money could be, hypothetically, how much money would later on be created from distributing this film. So we have, as Your Honors have pointed out, we have a perfectly good statute, 5225B. This is a statute that is used, it exists entirely for the purpose of,
Counsel,
yes.
Why isn't this other personal property which he has an interest under 5225A?
Because my client certainly has an interest in it, but in order to manifest that interest, in order for a judgment creditor to actually acquire possession over that property, an order must be issued in which the court has jurisdiction over the party who holds the property. In this case, the party who holds the property is Highbrook. Highbrook is the
So
form.
essentially what you're trying to do is, and where is the property being held, or the account?
It's held in account by Highbrook, and there's also a...
Where is it? Out of state?
No, it's a New York company. Highbrook is holding the money for the purpose...
And where the person is not, who technically holds the property is not in the state.
There's ways to do it. The court has reached certainly you could long arm out of state. These aren't issues that are at issue in this case in any sense.
There's no question the property is in New York and can.
Yes, that's what's going on here.
There's delay, right? I mean, that's maybe their concern that it's more delay and more expense and following the procedure.
The court should be aware that the appellant here has since this was filed, filed another petition under 5225B, and this one named Highbrook, and that's in litigation at this very moment.
It's not before us.
It's not before the court, no, but it's relevant. But no, there's no reason why a court simply couldn't bring the petition. I've been handling collection cases for a very long time, and in every single case when there was a bank account to be seized, my firm would issue a 5225B petition and name the bank that was holding the account, just like the appellant should have done here. The appellant is trying to obtain an interest in, or in some way argue that an interest in a piece of property should be obtainable, but that's stretching 5225A beyond what it was ever intended to be used for. If a third party is holding the property, you use 5225B. That's what it's there for. That's what literally the statute is labeled: property in possession.
If we were to accept your adversary's argument, would we be essentially making 5225B irrelevant?
No, I think what the appellant is trying to do would make 5225B irrelevant.
I'm saying if we were to accept the argument.
Yes, you would be. That's exactly what happened, yes.
Thank you.
Thank you very much.
That was exactly going to be my question to you, your question to
The answer is no.
opposing counsel.
The answer is absolutely no.
If we could do your maneuver, why would we even have a 2225B? Because they could always just say, we want the contract interest.
And I'd love to answer. Two reasons. Number
let you
one,
answer.
There are instances where the debtor itself may not be located in New York. For example, in ABCO, it was an out-of-state debtor, or in
I'm sorry, I'm having a little trouble here.
Sorry, there are multiple instances where the debtor is not in New York State, in which case the only party
Let's talk about
located in
this
New York.
case.
Let's
talk about a case where the debtor is in New York State, and there's no reason why you can't bring an action against the person who's actually in possession of the property. Why would you then have this distinction between 225B and 225A? And why wouldn't 225A then be meaningless if we accept your argument?
5225B is not meaningless. There are times where you could only use A. There are times where you could use B. This is an instance where you can use both.
But if we accepted your argument, couldn't you always use B and you never have to use A?
There are pros and cons of doing one way or the
So I
other.
always use A and you wouldn't have
All right,
to
well, of course. There are pros and cons of doing one way or the other. In theory, the advantage of B would be that you're directly going after what you're ultimately looking for, which is the money, and you don't have the risk of having to do a second step. Here, it was already disclosed to us that a second step will not be necessary, and therefore we didn't take that step. In fact, the record included that the parties explicitly stipulated it wouldn't be do it. It was a bait and switch that we were in this situation in the first place.
Counsel, isn't the real reason that the distinction exists between A and B a matter of the court's jurisdiction? That if you're trying to get property that is not within the jurisdiction of the courts, if someone's holding it not in the jurisdiction, that's why you have to have a special proceeding, versus if the person holding the property is within the jurisdiction of the court, you don't need the special
I would agree that
But aren't you in effect asking us to create an order which causes a non-party to be forced to turn over?
That is not true.
You're not letting me finish
Sorry,
the question.
apologies.
I know you're anticipating it, but to be forced to turn over the property without a court order.
Apologies. We are not issuing any order whatsoever to any third party pursuant to this motion. In terms of the jurisdictional point of
Wouldn't that be the
5220,
effect of this motion?
it would absolutely not.
If we let you go forward here, wouldn't that be the effect that the third party would be then forced to turn over the property?
I would not be able to seek contempt against a third party for violation of order. I have no order against them. I'd have to file a separate lawsuit against them to enforce my new contractual right that I've obtained. In terms of 25A and B, both serving jurisdictional grounds, that is true. And it is true that sometimes A is the only option and sometimes B is the only option. And it is also true that yes, in theory, B could be a more direct approach where both parties are in New York. That is absolutely true. We did it this way because A, we have the right to do it this way, and B, we all discussed in advance that this would be something that the third party wanted and the debtor agreed to until after the fact, specifically to cause more delay. We're only now first suing the third party because we were put in the situation.
Thank you very much. Cornelius versus Moody's.
Good afternoon. Russell Moriarty for the appellant. Appellant has brought 3 issues before the court in this matter. First is that the election of remedies doctrine should not apply here. Plaintiff filed a prior and separate division of human rights complaint.
Why shouldn't the election of remedies apply here?
Because according to the law, both actions have to have the same set of operable facts. They have to be based on the same incidents. They have to be based on the same events. And the 2 actions have completely separate all of those. For example, in the division of human rights action, plaintiff claimed that she was treated differently because of hyperhidrosis and anxiety in the workplace.
You didn't make a reasonable accommodation claim in the state action?
I believe with respect to the hyperhidrosis.
My recollection is that there's a letter there where she requested return to work on a part-time basis.
That's not in the division of human rights complaint. I believe in a rebuttal.
But it wasn't that letter attached?
I believe it was attached in a rebuttal to something, but it didn't go to the pleadings in that case. So essentially, it wasn't part of the ruling and adjudication of that case for that reason. So in the lower court case, in this case, she actually brought a specific claim for failure to provide a reasonable accommodation to be returned to work on a part-time basis. And that certainly wasn't in the pleadings in the Division of Human Rights action.
Sexual harassment claim by the co-employee certainly wasn't raised.
Exactly. Division of Human Rights claim was not about anything to do with sexual harassment whatsoever. And the case law is clear. It has to be same incident, same people, same events, so on and so forth. So we respectfully request that that doctrine not apply. The second issue before the court, the lower court concluded that the defendant did not know or could not known of the sexual harassment that occurred. And the court essentially took the defendant's side, weighed the evidence.
How do you impute that? I think the question is how do you impute the sexual harassment claim to Moody's?
At least 2 ways. Plaintiff complained to the team lead of the person who was the team lead of the person harassing her. So that person was held out to be the supervisor.
Wasn't there an argument being made that that person did not really have any supervisory authority?
There is that argument.
Being called a team leader?
Sorry,
What is wrong with that argument?
Is being made, but plaintiff actually provided testimony that that was not the case in the workplace. So there are competing facts here which a jury should hear about, and which the court should not have weighed in the movement's favor, and the court did.
What facts were presented that this person had any kind of managerial or supervisory authority?
That person was held out to be the supervisor of the harasser.
What evidence there other than the bare allegation? I mean, what evidence is there that he had concrete supervisory authority?
Directed the harasser as far as the work that that person did, number one. And I believe we had testimony from a person on that team who confirmed that that was the team lead of the harasser. But there's also a second reason. Plaintiff alleged very clearly that she tried to complain to her own supervisor, who certainly had supervisory authority. And when she went in to complain, that person said he didn't want to hear any complaints. And
Is that about that specific? I thought her testimony was that earlier she had complained and he said, I don't want to hear anymore, but it wasn't about that specific incident. It was about early incidents, so she felt that she wouldn't be heard, but not that she actually went and ever spoke to a supervisor other than the team leader about that specific incident.
So actually 2 points to that. First of all, she was warned previously by her supervisor that if she complained anymore, she wouldn't be put on projects and that would hurt her career. So first of all, she was discouraged from bringing the sexual harassment complaint. And I believe that in and of itself should mean that the employer should have known if they didn't discourage her from complaining.
What were the early, I'm sorry, go ahead.
there were other complaints that she made after that, right? After this alleged sexual harassment incident that were addressed by her?
Correct. So the earliest complaint that defendants acknowledged was about 8 months into her leave of absence. She had a phone call with, I believe, human resources people, and they accepted her complaint at that time. But she never returned to work, so at that time we can't say that the harassment continued because the
Isn't there
employer felt-
evidence that they took immediate corrective action and took steps to remedy her claims about this employee?
8 months after she
Well, so
left the
she
workplace.
told them. But the timeline based on when she told them about this incident and the actions they took, wasn't that pretty immediate?
The third time
She
she
didn't tell
complained.
them until she was out of work for 8 months.
But the point is, she told the team lead, she tried to tell her supervisor, she was,
Wait, I want to get back to that.
Sure,
That she tried to tell the supervisor.
yes.
Did she tell the supervisor, or did she attempt to tell the supervisor, that, hey, this guy Drew is harassing me?
She walked into his office to make that complaint. She testified that. She walked into his office, he told her, I don't want to hear your complaints or something to that effect, and she had to leave. So she testified to that, and I believe a jury should hear that because those facts are important. She was discouraged previously from complaining by that supervisor. She was sent away from his office on that particular occasion, so the employer should have known, and that's the argument for this particular issue. One more issue, right?
We have 5 seconds left, so don't say anything too complicated. I'll
Okay,
save it for
will do.
rebuttal.
So
Actually,
as,
save it for rebuttal because your time's up.
okay, thank you.
Good afternoon, Your Honors. David Garland on behalf of the respondent.
Can you address, at least for me, the sexual harassment claim? One, you heard your adversary say that goes into the office, wants to make a complaint, and the supervisor says no complaints, and she's compelled to leave.
So that's not what the record shows. That's what the argument was today. The record shows that she went into the office that day, actually was complaining about the environment that day, and then leaves the office and never comes back. She doesn't raise the sexual harassment complaint until over a year later. And then, to the point, as soon as Moody's learns about that, immediately investigates, takes corrective action, issues a warning to the alleged harasser, who's a coworker. Therefore, Moody's is not liable for that, even if there was harassment, that alleged harassment, and nothing ever happens again.
What about the disputed issue of fact allegedly about the team leader, that whether or not that team leader was a supervisor or not?
Well, I think the way you pose the question, I think alleged issue of fact, there really isn't any issue of fact here
I didn't
because
mean
the
to
admissible
prejudge it, I'm
evidence.
sorry.
I'm sorry, Your Honor.
I didn't mean to prejudge it. I was just asking.
No, and maybe I mischaracterized Your Honor's question. If I did, I apologize. But the point is that in the record, there is no dispute. There's no evidence other than what? Yes, I claim he was a supervisor, but we went through and asked, did he have managerial responsibilities? Did he have the opportunity to discipline? Did he have the opportunity to make promotion decisions? Did he was managing?
Your adversary indicates that there was testimony that he directed others' work.
But there's no admissible evidence, Your Honor, on that point in the record, none. The strongest point that they make is that they because the title of team lead somehow means he was supervisor, but you have to look at the facts in the record. And these issues that we're talking about, we only reach those issues, the court only reaches that issue if the election of remedies doctrine doesn't apply. And I would submit that it does.
Wait, with the sexual harassment, I'm not sure I agree with you that the sexual harassment was raised before.
So, Your Honor, this department, and one of Your Honors was on the court in Bradshaw, and we put into the record, in the briefs, the facts in Bradshaw. And let me just briefly say, so in the state division complaint in Bradshaw, the individual, the employee made a disability discrimination complaint. The State Division of Human Rights dismisses that, no probable cause. Then the plaintiff comes into state Supreme Court and alleges sexual harassment, and the employer moved in Bradshaw, election and remedies doctrine, motion court granted summary judgment, and this court affirmed that summary judgment in its 2021 opinion, and very succinctly pointed out those distinctions that I just articulated for you, and said the plaintiff expressly alleged in the agency complaint that defendant engaged in retaliation and created a hostile work environment. Different claims, but the same core of conduct, the same period of time. And so the election of remedies doctrine applied. And there are other opinions too, which we cite in our papers, from this department and others, as well as federal courts interpreting state law, that on similar sets of facts have held the election of remedies doctrine applies. And the last point that I wanted to make in my time is that the whole notion that there was a termination here, there isn't. I mean, the record is undisputed that Moody's repeatedly reached out to her to see if she's going to come back to work, and she didn't, and gave her opportunity after opportunity, and she didn't take advantage of that, said, I am not returning. Hence, any claim based upon termination was properly dismissed because there was no unlawful termination.
There was a letter sent that one might argue, I think it was the April 20th letter, that there was a termination.
So even if one argued that, Your Honor, I think the response was, no, there isn't. And you still can come back. And then again, the response was, no, I'm not returning. Thank you.
Thank you. As far as the termination, that response was a year later after she was told she can't just come back, she has to reapply. There has to be an open position and she has to be qualified. So that's a termination.
Indicate that she was offered 3 times to be reinstated. Is that correct?
Not between the time she received that letter and the conversation where she's told she could come back. But I'd like to just get to Bradshaw for a moment, because my recollection of that case is that it was still the same conduct. All of the allegations in both cases were related to the termination. So sexual harassment and then terminated, disability discrimination and then terminated. That's my recollection of Bradshaw there, which is why we're arguing that's not applicable here. Thank you.
Thank you very much. Golden Nugget versus Chan.
Good afternoon, Justices. May it please the Court. Leonard Spinelli, Pemlaw LLP, on behalf of the appellant Wayne Chan. I'd like to focus my time on one issue that we've raised in the briefs, which is the non-transparent dice issue. I think.
Why isn't that issue preclude? That issue was addressed by the New Jersey Gaming Board.
It was not, Your Honor, and I can explain why.
Well,
so,
let me finish my question.
Of course.
As I read the record, that issue was addressed by the New Jersey Gaming Board, and you didn't, as far as I can tell, I don't think there was a challenge to that finding in New Jersey. We're bound by it, so I'm not sure why that's an issue we should be dealing with.
So the reason why it's an issue we should be dealing with is because what this court said and what the New Jersey Supreme Court said in Campione is that the DGE and the CCC have primary jurisdiction over the interpretation of the act. It's not a...
Right, and doesn't that include what transparency of dice means?
It includes what transparency of dice means, but I think what we're missing here is the fact that the investigation conducted by the DEG looked at 2 new sets of dice manufactured by GPI and by Midwest Dice Co. What the DG did not look at is any of the records related to the dice that were in play.
Well, that's partly because the dice are required to be tossed after 24 hours, so the actual dice he would have played with would be gone by then.
Right, but the regs require the casinos to keep records relating to those dice. They're required to keep a log for each approved storage area.
And was that issue raised before the New Jersey Supreme Court or before the gambling?
No, we didn't have an opportunity to raise it before the Gambling Commission. We've raised it on appeal. That New Jersey Appellate decision hasn't been decided yet. But the point is that the Campione decision is very clear that the courts have jurisdiction over the claim. The DGE has jurisdiction over the interpretation of the act.
Well, let me ask you a question. Is there anything in the record on that issue of the transparency of the dice and whether or not the DGE interpreted, I guess, the rules correctly in terms of the dice need to be thrown away? Was there anything in the record that indicated that your client notified any one of these claims immediately within the 24-hour period so that they could have maybe preserved
Absolutely,
that
Your Honor.
dice?
Yes.
Where is
So
that in the record?
that was in Mr. Chan's certification. That's at, that's at record 83 is his certification, 85 and 86 are the photographs.
His certification where?
His certification to the Supreme Court, to the Supreme Court. It was also raised in his patron complaint, which was also part of the record. And there's a disputed element of fact that's evident in Mr. Chan's certification, and it's raised in it's evident in the DGE decision. And the disputed issue of fact is that the casino denied ever having been notified of that complaint. Mr. Chan disputes that. And he says specifically that he raised it to the box person and the manager, whose name was Karen, and the individual identified that was interviewed at the time, her initials were KL. We have no further information on that, but they should be under an obligation to preserve the dice at that point once they're on notice that there's a dispute. Now, the fundamental issue I think we need to address, though, is that this is not a question of an interpretation of the reg. This is a question of fact. This is a question of, were the dice used in the specific game compliant? And that is not within the purview of the DGE. The DGE...
Even if you're right about that, wouldn't you need an expert here to say that, that the dice don't meet the transparency requirements of the regs, et cetera?
So we potentially would need an expert, I think, but unfortunately we don't have the dice. I think potentially we could be entitled to an adverse inference.
We'll never have the dice.
We'll never have the dice.
Did your client test the dice before and after?
No.
Play?
No, I believe he took photographs of them, but that was it. And so getting back to what I think is really critical here is the question of fact relates to the games that Mr. Chan played, and we have no discovery. We have no documents. We have no records. We have nothing that...
Did you make a demand in 3 years?
I'm sorry?
Did you make any demands for records?
We did not. They moved for summary judgment pretty much out of the gate. And then we came here, it was remanded back, and then they moved for summary judgment again. We've never even had a preliminary conference.
How many years has this case been going on? 3 years?
Few years, Your Honor.
3 years, right?
3 years, yeah. It was 2021 filing.
In those 3 years, did you make one DNI request?
We did not, Your Honor.
Did you make a request for an EBT?
No, we did not, Your Honor.
Thank you very much.
Thank you, Counsel. Thank you, Your Justices.
Good afternoon, Your Honors. May it please the Court, John O'Brien, Berlandi Nussbaum, and Reitzes for the respondent, Golden Nugget, Atlantic
Counsel,
City.
on this issue of the dice and the reporting to the casino immediately, what's your response to your adversary's position?
My understanding of the record is that Mr. Chan claims to have spoken to a casino personnel at some point in 2019, and he was told to file a patron complaint. Patron complaints are located in every casino as security desks that are available to have a direct complaint to the Division of Gaming Enforcement. He chose to file a complaint on January 14th of 2020, and the DGE conducted an inspection and interviews in January and February of 2020. So contemporaneous with his complaint to the proper channel, they inspected the dice. But I think, Your Honors, this case it should begin with this court's prior ruling in April of 2023, in which the court found that summary judgment was premature because the DGE had not yet ruled, and reversed with leave to renew summary judgment upon a ruling by the DGE, who of course has primary jurisdiction on questions of whether there was a violation of the act. I think there is a little bit of a distinction here that the Gemico court gets to and the Campione court gets to, which is that the DGE gets to decide whether there are violations or whether there is compliance. The courts get to decide what that means. In other words, does that mean it's about...
Here your adversary argues that it's a factual issue with respect to the degree of transparency of the dice, and that's within the purview of the court.
Well, Your Honor, I would say that there is not a factual issue with respect to whether or not that was sufficiently transparent for the regulatory agency charged with doing so. In other words, they inspected that dice. I think at a point I would make there's two issues. One, the dice are not required to be clear, right? They're allowed to be any number of colors, and in fact, for gaming purposes, it's better if they're slightly darker because the number pops up. So you don't have a bunch of people playing craps and saying, no, that was a 4. You know, everyone can clearly see the numbers. Second, just because they look dark, I mean, a dark pair of sunglasses can look very dark from a distance, like opaque, and then you put them on, you can see through them. There's nothing in the regulation that says they have to be, you know, a certain lightness, they have to be a certain whatever. The DG is in the casinos inspecting it. They say this is good enough for us. And GNAC, Golden Nugget, is entitled to rely on that. And that is, you know, the Campione court, what this court relied on earlier, that's exactly what they said. You know, the DGE is the primary regulator of this, and both parties are entitled to rely on that, and courts should not step in and create confusion where uniformity is required. Second thing is, this case is not a question of whether he was improperly denied discovery. He never made a discovery demand. The question is whether he has raised a triable issue of fact, and he has not. He has only created unsubstantiated allegations. Well, maybe everything changed in the 2 months since I filed my complaint. Maybe they were using illegal dice. But with respect to, that's not, there's no facts underlying that. This is nothing but mere hope or expression he might find something. With respect to whether or not he can have an expert in to say whether these conform with the regulations, that is why there is a micrometer, a balancing test, a magnet, a square set at every table, and why they're inspected before and after they're put in play. These are the tools the regulations mandate be used to determine that the dice are fair, balanced, and legal. So what would an expert come in and say? I've used different tools. Well, excuse me, if I just 20 seconds to wrap up here. Okay, the only thing relevant are these tests. And for those reasons, Your Honor, if there are no further questions, the judgment should be affirmed.
Thank you.
2 points.
Counsel, if I could just
certainly.
ask the 2 follow-up questions as to the patron complaint. In January 2020, that month, that's when your client filed his patron complaint?
That's
But
correct,
the debts that were owed, the $200,000, that was back in 2019. So presumably,
It was November of 2019. Now, this is something that is not in the record, but.
well, then we don't need to hear it.
I understand, but I think it's an important point because it was November of 2019. It's when those and this is in the record, the cashier's checks were drawn in November of 2019. It was 2 checks for $100,000 played in one game.
And then they were dishonored for insufficient funds.
That's correct, Your Honor. Okay, and that's when the losses occurred. That's when he raised his complaint.
And
then
that's,
in
so presumably
January-
that's when the dice issue, I guess, started, or for him, not started, but that's his claim in those particular games where those debts, accumulated,
That's correct, Your Honor.
right? But
Yes.
his complaint wasn't filed until a month later.
About a month later, yes, Your Honor. Now, there's a couple of issues I'd like to address from Mr. Counsel O'Brien's opposition. First, Mr. O'Brien makes the argument that because the dice are strictly controlled by regulations, there can be no violation. That's a false syllogism, because essentially what he's saying is, we have these regulations and controls, so therefore we have no defenses. But there's no facts in the record that those regulations and controls with respect to these dice in these games that Mr. Chan played in November of 2019 were actually complied with. The second point is the issue of Gemico. The Gemico case and the Campione cases both say that it's the interpretation of the regulations that that the GGE and CCC have primary jurisdiction over. And if I could just finish my thought, what the DG investigated or inspected were new sets of dice. There is a question of fact based upon Mr. Chan's certification whether or not those new sets of dice that were examined by the DGE were actually the same manufactured dice used in those games.
Thank
And
you.
that's the point of discovery,
Thank you
Your Honor.
very much.
Thank you.
Paley versus Curious Holdings.
Good afternoon, Your Honor. I'm John Ponterio. I'd like to introduce Ryan Powers, who has admitted pro hoc vice to this court, and with your permission, will argue the appeal for the appellants.
Good afternoon, Your Honors. May it please the court, Ryan Powers for the appellants. There's 2 issues I want to raise that were raised in the brief. The first, the lower court erred when when they found joint and several liability at the summary judgment stage against 5 separate defendants on 8 causes of action without any specific findings, without any specific reasoning, or with any specific justification. Now, this is particularly problematic because the DCL claims, the fraudulent transfer claims, they were already dismissed against the individual defendants.
You want to address the piercing the corporate veil argument as to those 2 individual defendants?
Yes. So because they were already dismissed, the only way they could be held liable is under some alter ego theory of liability. Now, again, as I mentioned, there were no findings of fact in the court's order regarding piercing.
What does the record say with respect to, for instance, with respect to Coberlin?
Right.
On this
So
issue.
There's no evidence in the record of any commingling of funds. There's no evidence in the record of any of the funds.
Well, did Coberlin follow corporate formalities when he liquidated Curious's assets?
Yes. Coberlin followed Delaware law when he wound down Curious. Now, Curious became eventually insolvent, and it was never, formal wind down documents weren't submitted to the state to finalize the wind down.
Well, yeah, because Coberlin took all the assets out. All the assets and the employees went off their merry way to the other companies.
Well, the Curious asset was already $1 million in arrears and defunct prior to this, and he was ordered by the sole shareholder to wind down the company. Now, the sole shareholder was aware of the one asset, this what I'll call the Disney Project series. He was aware of this series, and it's in the record. He's talking to Coberlin about it, about getting that Disney series. Is it a possibility? But it was not a possibility. It is a fiction that Curious could have ever produced that series.
Wouldn't that be an issue of fact for trial?
It would, and that's another reason why this shouldn't have been disposed at the summary judgment phase.
So let's going back to the alter ego. How about the wife? How about Grasick? Is she an alter ego of Microseries?
No, both Microseries and Milk Barn were legitimate companies. Microseries, for example, had produced several other series in addition to this.
What
one.
about
Well,
Milk
that may,
Barn?
Sorry?
What about Milk Barn?
Milk Barn was also a separate entity set up in New York.
Is it a shell
Did it
company?
have employees or any business going on?
They were set up for the particular purpose of producing the series.
So
it
why
was
isn't, go ahead. Why isn't there an argument as to them that corporate veil could be pierced?
The corporate veil could not be pierced as regard to Grasick because none of the assets or benefits went through from the series to Milk Barn to Grasick. Everything lived at the corporate level and remained at the corporate level.
But if Milk Barn really, as you acknowledge, I think, it's essentially a shell company until it gets the Disney PSAs, and now it has a meaningful existence. It seems to me that there may be alter ego liability in those circumstances.
Well, the court has found specifically, I cited Cortland v. Recovery, that you can't pierce the corporate veil against a corporate officer unless you can show there's some personal benefit going back to those individual defendants. And the record is devoid of any personal benefit going back to Marina Grasick.
Wasn't she the sole owner of Milk Barn?
Yes.
And all of the employees and business that would have been in Curious went over to Milk Barn, right?
Eventually, the project was greenlit nearly 18 months later, and many of the same employees were hired by Milk Barn to produce the series. And real quickly, one more issue I wanted to note is we failed to see how a judgment of $1.4 million could be leveraged against these defendants when it is impossible to reach that calculation, and I'll explain. Under the DCL claims and...
So let's be clear. You're talking about now the profit in the Disney production.
Yes,
correct?
because the damages are limited to the value of the asset, and the value of the asset is a hotly disputed fact. Under those
Are you arguing there should be a hearing as to that issue, what the value of the...
it clearly could, in my argument, it could not have been resolved this way at summary judgment. There needs to be factual findings as to the value of this asset.
and as to what issues do you believe there should be a hearing?
Well, piercing the corporate veil and the damages, at the least. Thank you.
Good afternoon, Your Honors. Nadir Mobarga for Respondent Jonathan Paley. So,
Counsel, clearly the court did not engage in breaking down the different causes of action and the different defendants. what is your response, at least since he started that, with the individual defendants and their liability, since the DCL claims were clearly dismissed against them? The only basis for liability is piercing the corporate veil.
My response is simple, Your Honor. My brief briefed the veil piercing issues. Their brief did not. They didn't address it at all in their brief. That they focused on jurisdiction. They were trying to get out of the jurisdiction, and they focused on it was about the transfer. Their brief did not address the proper factors, and Mr. Powers discusses that this benefit is not a sole factor. It's just, first of all,
But let me just ask you this, counsel, at least to Corblin, in terms of Curious, he was just the CEO. The actual owners were Griffin Pictures?
Yes, Griffin was 89% shareholder, and
at one point they were 100% though, right?
yes, well, they were never really 100%. Once my client vindicated his equity, it was 11% for my client and 89% for Griffin. And I also want to just refute Mr. Powers' contention that they told the shareholder about this. There's a November 5th, 2013 email, 1 month before the liquidation. It's record 182 to 181 to 182. Basically, the shareholder says, so if we do not get this Disney contract, we're going bust, right? And Corblin doesn't tell him that there was already a production services agreement signed from July 2012.
Yeah, but that assumes that Curious could have actually produced. What your adversary argues that at the very least that there's an issue of fact as to what Curious could have done with that property.
Well, the Curious was producing it. They had produced the pilot.
But their response again is that they're going bankrupt. Why shouldn't there be, at least with respect to that issue, as well as ultimately what the value was of the production? Why should there be a hearing on that?
Because, Your Honor, the simple question is there was $17 million of production fee coming in from Disney.
That's not all profit, right?
No, it's not profit, but the production, no, that was the budget. The production fee was a fee, basically like a flat fee.
What is it, the production fee goes to paying the producers and the assistants?
It doesn't. The budget, as I mentioned in the statement of facts, covers everything involved with the project, every single thing, all the people who work on it, everything. The production fee, all they ask the production fee to cover, which is what the contract says, is it just cover like basic overhead, which basically the reason why Disney asked you to do that is because they want to make
in this case, what was the basic overhead?
I'm not exactly sure what the number is, but the shareholder did say.
Then how can the court just decide this is the number? It's $1 million plus.
Well, because that was what was taken. So just 2 points, if I may. The shareholder also said, had he known about the project, he would have provided an equity fusion into this company. He took Corblin's word for it. Corblin hid that fact from him, and therefore they shouldn't have the benefit of it. They didn't tell the 89% shareholder that there was a $17 million project that's coming in. And Corblin testified, uncontroverted, that had he known about it, he would have provided an equity fusion to sustain the minimum operations for going forward. And I'll also quote one aspect of a case from Alexander versus Alexander from this court. So it would be imprudent to hold that employees and corporate officers could exploit opportunities solely on the grounds of their claiming the legal inability of the company to handle the project, because it disincentivizes them to tell the shareholder what's going on or to actually work through the solutions themselves.
Talking about the liability under the DCL, not the valuation issue.
Sorry?
You're arguing now about the liability under the DCL claims. You're not arguing the valuation issue. It's one thing to say, yes, you made out a valid DCL claim, and it's another thing to say what the value of the claim is. So
yes,
you seem to be arguing whether there was a DCL claim, but the more difficult question is whether we should accept the valuation the court gave or remand it for a hearing if we uphold the DCL claims.
I understand your question. Well, there's no reason for evaluation because our judgment was $1 million and they transferred $1 million. Sure, there's probably a chance that we can sit there and do an analysis of the valuation of the Disney project at the time that it was transferred. And it probably had a lot more value than production value that Disney paid it. But we don't need that. And so also one last thing is—
No, your time's up.
Oh, sorry.
But thank you very much.
I'll just refute a few issues brought up by my opponent. One, the asset value, which Your Honor had noted, it can't equal that amount because this overhead, this rent, all this money had to come out of it.
Suggestion is de minimis, I think, is what I'm, or at least what I'm
Well,
hearing from your adversary.
Not only was it not de minimis.
So what is it?
We know because it was actually produced.
In the record, so from the record, what can you say it is?
It exceeded the cost. It was a loss. The entire production was a loss. That's.
Oh, you're saying that your clients made no money on this?
Yes, and it's in the record. We have the budget in the record, and it was in fact such a loss that my clients ended up suing Disney. They lost so much on this project, which goes to the value of the asset and the fair market value paid for the asset. There's so much risk in producing a television series. This is an episodic fee paid over 24 episodes, which took over a year and a half. It was capped regardless of the budget. That was all they're ever going to get, and it didn't cover it. Jan Corbelin didn't even get his salary paid out of it, his executive producer fee. So this was ultimately a loss. So to hold that somehow this asset could have enough value to render a judgment for $1.4 million would be an injustice.
Thank you. New York Marine General versus Cookman Best Insurance.
Good afternoon, Your Honors. May it please the court. Kathleen Devlin from Weber Gallagher on behalf of the appellants, New York Marine and General Insurance Company, as well as 3105 Decatur Associates LLC. The issue here is whether a carrier is obligated to provide coverage to a named additional insured for a claim arising from an accident that took place prior to the time that the named insured requests retroactive cancellation of the policy.
Counsel, there's very little law on this topic, but the law that does exist, doesn't it support the principle that it's okay to do a retroactive cancellation between the insurer and the insured as long as they didn't have knowledge of the underlying incident?
In Your Honor, yes, it is. There is sparse law on this.
So is there any evidence that they did have knowledge?
Cookman did not have knowledge of the claim as far as we know, but in the Cosmopolitan case, the Court of Appeals held that an insured and insurer are, of course, free to agree upon the cancellation flat of a policy so long as the rights of no third party are affected.
Right, but between Cosmopolitan and then the later elucidation in Jerusalem, which is a First Department case, don't those two cases combined support the proposition that it's okay to have a cancellation as long as there's no dispute that they didn't have any knowledge of the claim at the time they did the retroactive cancellation?
We submit that the Jerusalem case, it could be distinguishable here. In the Jerusalem case, on February 24, 2006, the tenant met to request cancellation of the policy retroactively.
And I'm sorry, why is Jerusalem? Why is Jerusalem distinguishable?
That's what I'm explaining, that Jerusalem was distinguishable because on February 24, 2006, the tenant had requested a retroactive cancellation of the policy. The accident also took place on February 24, 2006, but the exact time of day was unclear.
But wasn't the holding of the court that if there was no knowledge, then it was okay to retroactively cancel? I know those were the specific dates in that case, but wasn't the holding broader than that?
Well, the court held that the policy, the issue really in Jerusalem was the timing, whether it was canceled at 12:01 on that day or later on at 11:59, and that was really the focus of that case, and the court held.
Let me just make sure that I'm clear to understand. New York Marine is not disputing the fact that the defendants did not have knowledge of the, I guess, the accident prior to their retroactive cancellation.
Not that we're aware of. But both the insurance company and the insured are third-party beneficiaries. The Decatur was a named additional insured on that policy, and clearly they were prejudiced because they had no notice of the cancellation of the policy. And similarly, New York Marine is prejudiced, just like in the Cosmopolitan case, where the court held that a co-insurer of Lumberman's was a third party whose rights were directly impacted. Similarly here, New York Marine.
But why don't those two cases combined stand for the proposition that the risk only matures after the notice of the accident is given?
We submit that
Vis-a-vis the rights of the third parties.
third party. Cosmopolitan addressed that briefly. They referred to it as a matured risk, and it said that it is clear that Lumberman's, while it was on only insurance carrier protecting the insured, could not have effectively canceled the binder after the date of the occurrence. The right of the injured party to proceed against Lumberman's had fully matured at that time. And these are occurrence-based CGL policies, which means the date of the occurrence here, the accident, that's when the policy is triggered.
So then it's your position that knowledge of the accident doesn't matter?
Well, that's the rule. That's what I'm trying to understand. Is that, and I was going to ask that question, is that the rule that you're asking us to I guess, maybe move away from Cosmopolitan, it's just the occurrence and nothing more, and you don't need knowledge of the occurrence is not a necessary prerequisite?
Well, that and also the prejudice to the...
Are there any cases that support that position?
Well, in the Truax case, the court found that cancellation is not effective until notice of the cancellation is received by the insurance company. And that case referred to Russ Toggs versus Fidelity Phoenix, a Court of Appeals case, which held substantially the same thing. And here, of course, the accident took place long before the cancellation was even requested or allowed retroactively.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Sheila Alipur on behalf of Defendant Respondent, KBIC, Cookman's Best Insurance. May it please the Court.
Counsel, this accident happened in, what was it? Late 2016, December 2016.
New Year's Eve, December 2016.
Okay. And the store purportedly closed March of 2016.
Correct.
Were premiums paid monthly or yearly? I guess because it kind of, to ask for retroactive cancellation back to almost a year to when you actually made your request is kind of, it boggles my mind as to the timing if premiums are still being paid out.
Right.
And the store was actually closed.
So in this case, the policy was canceled after the policy expired. So throughout that time, the insured had been paying their premiums. Now, retroactive cancellation is something that is uniquely, the insurer has the ability to limit the right of the insured to retroactively cancel to prevent the situation that Your Honor is alluding to, that at the last minute, that the insured would simply request retroactive cancellation when no claims had been made. I think Your Honor correctly pointed out that the essential point in this case is the knowledge of the accident. And in the cases that do address this issue, this through line is common throughout all of them. Beginning through Cosmopolitan, through 210 Jerusalem, through to Dujevec, through to even Traux, it is clear that when the insured and the insurer do not have knowledge of the accident at the time the request for cancellation is made, the retroactive cancellation would be effective.
Is there any evidence that the insured had notice of the accident?
No, Judge. The insured never gave notice, and in fact, the insured is in default in the underlying, and no one's really heard of them. The point is that the position being taken by appellant, if this court was to adopt it, it would be nothing short of a sea change in insurance retroactivity law. No insurer would agree to retroactively cancel a policy because if there is a claim that may be made at some point waiting in the wings, then the insured would be stopped from retroactively canceling. And this court and the Court of Appeals have...
How common is that, though, the retroactive cancellation of a policy? How often does that occur?
Well, certainly, Judge, it has happened, and it can be used for nefarious purposes. In the Meinwieser case, we saw an instance where an insured and an insurer agreed between themselves to retroactively cancel a policy that had expired decades earlier. And the insurer knew that there was countless asbestos claims that could have implicated the policy. But in order to avoid that, the insured and insurer agree to retroactively cancel it. So knowledge is the...
What happened ultimately with regard to that?
Sorry, Judge?
What happened ultimately with regard
Well,
to
the retroactive cancellation was deemed to be invalid because...
Because it was notice.
Exactly, because the insurer specifically had knowledge of the potential claims. In this case, Judge, there is no evidence that either KBIC or Norwood had knowledge of the accident at the moment, January 26th, when they requested the policy be canceled. Ours have no further questions, and we rest on our briefs.
Thank you.
Thank you.
Just briefly, Your Honors.
How do you respond to that argument that, that there is essentially maybe a policy argument being made as to why courts focus on the issue of knowledge?
Knowledge of the underlying
The occurrence, yes.
That is an issue, but there's another overriding issue as to prejudice to the third-party, intended third-party beneficiaries of a policy, such as the additional insured here, who was an actual identified additional insured.
Wouldn't we be overruling prior law, which does focus on the notice as a pivotal issue if we held otherwise?
Those cases may not have involved prejudice to third-party entities, such as the additional insured here, who was identified, page 401 of the record.
But there would always be prejudice in a sense, because every time if there's a retroactive cancellation of the policy, that policy is not in place for an additional insured to look to, correct?
Depending on if there was prejudice or not, yes.
Thank you.
Thank you.
Donaldson versus Port Authority.
Good afternoon. William Costigan for Appellant Mary Beth Donaldson. The Port Authority failed to establish as a matter of law that it met its duty to make its walkways reasonably safe.
You concede that they preserved the issue below?
I don't concede that they argued that in the court below.
Well, that's what I'm asking. Do you concede, because the way you're starting suggests that you are conceding that. Do you agree that they...
No, it wasn't in their brief. Well, all they did in the brief was re-argue the points they lost before in this court.
But the affidavit of the expert, as well as the police expert, and all the other supporting documents to their motion for summary judgment would suggest that they had enough, at least, to meet a prima facie burden. And that's exactly what the court used when the court analyzed the issue under the negligence standard, which would be in accordance with what was held in called Feldman 1, that it's a negligence standard. And all of those documents do support that issue. In opposition to that, the plaintiff doesn't really submit anything to counter the expert's affidavit. It's 2 articles and the report of the incident and maybe one other document that doesn't have any other kind of certification with it. So I'm just wondering, where did the court err in analyzing the negligence standard?
The first point I would make is because they didn't argue it in their brief, we could not know what the court would make of a few thousand pages of additional material and where that would take the court. What we had were very specific numbered Roman numerals 1, 2, 3 arguments that essentially just renewed the attack on this court's prior decision, describing it as completely wrong-headed, a flawed analysis, et cetera.
But oh, no, go ahead. I'll let you finish and then I'll follow up.
To answer your point regarding a prima facie case, much of the deficiencies in their submission are actually in the Gorman affidavit, can be divined from the Gorman affidavit. He's the expert. And other materials from the Port Authority that were
right, but the Gorman affidavit does address the reasonableness of whatever work needed to be done, and it went through analyzing how work could be done, the standard for height of railings on bridges. It was very in-depth, and wouldn't the plaintiff, having received that in opposition to that, submit their own expert that maybe says something different.
He made a general argument. First, it begins in 2009. The bridge was built in 1931. It was there for 78 years, suicide after suicide after suicide, no fence, no explanation from Mr. Gorman. He doesn't even acknowledge that. Second, the Gorman affidavit does describe how in late 2016, they made a decision to install a temporary fence, which would save a lot of people. Not until late 2016 did they even decide to do that.
Right, and
Cost
then
a few million
then he
dollars.
goes on to analyze how, you know, one side would have to be closed, another side would have to be closed. There's wind studies that need to be done. It's not something that could be done overnight. My question to you is, having received that information in an expert affidavit, where is the plaintiff's expert opposition to that?
We did not engage an expert. We did not have time to engage an expert and respond to the motion. All of this occurred, there was factual discovery ongoing in the other cases, which were parallel to this one, but no expert discovery, no expert reports.
Counsel, is your position that the affidavits by themselves could not establish defendants' burden on their motion for summary judgment without legal argument tying what was in the affidavits to the legal standard?
Could not do it without legal argument, but even with legal argument would be deficient. No explanation for the failure to take any action before 2009. No explanation for the failure to even consider a temporary fence until late 2016, which is far too late.
Now questions with respect to reasonableness. Is that a question for or is it an ultimate question for the jury, or is it something that we can just resolve based on what the expert says here is the reasonable steps they took to prevent suicides?
It's absolutely a jury question, certainly not an engineering question. And finally, at any time, they could have closed the walkway, and they just didn't do it.
Thank you.
Nothing about that in the expert report either.
May it please the court, Cheryl Alterman on behalf of defendant, respondent, the Port Authority of New York and New Jersey.
Well, counsel, I mean, you got our decision from, you know, the Feldman 1 case, we'll call it that, the motion to dismiss. And then in your summary judgment motion, it seems to be more of a re-argument of those same issues.
It's not a re-argument, Your Honor. What we did in preparation for a summary judgment motion is we retained Kevin Gorman, who is our professional engineer and also police expert. We exchanged through a 3110D disclosure his report prior to filing a motion for summary judgment. We relied upon that report.
Why wasn't there a section of the brief that's argued we have satisfied the duty we have as articulated in Feldman 1?
What we did, Your Honor, is rely on the report within the brief itself. There are multiple citations.
Wait a minute. What your adversary is arguing,
yes,
but he's not saying it, and I'm going to say it, is that they were sandbagged because you did not specifically say in your brief that, in fact, you met the standards of negligence. There's no question in your affirmation, no question in the expert reports that there are references to that. Why did you not just come out and say, rather than re-argue our decision, which is ultimately you need to take to the Court of Appeals and not do it in this fashion, why didn't you, point one, say that we did everything we needed to do that was reasonable under the circumstances, grant a summary judgment under the negligence standard?
Your Honor, we believe we did in the sense that we said that the defendant met its burden to establish summary judgment that the bridge was maintained in reasonably safe condition.
Right, but you couched that.
Based on, I'm sorry.
I think we're going to ask the same question.
To the extent to which you did that, it was based on the proprietary standard, not on the negligence standard. Why didn't you do the other?
The reason for that, Your Honor, is because the bridge itself is maintained. The Port Authority operates the bridge in itself in a governmental function.
I understand you think that our decision in Feldman is wrong, but it's our decision, and it sort of amazed me that you were simply ignoring it in your briefs and arguing that we should apply the standard which we rejected.
We're not ignoring it, Your Honor. What we did, and we took it to heart, and that's why we retained Kevin Gorman as an expert to establish the reasonableness and all the effort that went into.
So then it was sufficient to put it in your affidavit. You didn't have to have a separate heading in your brief, as long as you submitted factual evidence to support meeting your burden.
Yes, Your Honor, and it was well established in our statement of facts. I mean, our statement of facts.
Well, that still doesn't answer my question. Why was that not your number one issue? We've all read briefs here. Why didn't you simply say what I've already said?
The decision was made, Your Honor. This was the best way we felt we could portray our argument through the affidavit of Kevin Gorman to go through.
How does that put the other side on notice, right? So that they can now say, well, let me go get my own expert and address this issue of reasonableness that they're arguing that they have legal support for. And then if was it proper for the court, which is really the main issue, is it proper for the court to then now analyze it under this negligence standard when in your motion for summary judgment, in your memorandum, you're mostly arguing the government issue?
Your Honor, we argued both. We argued in the alternative. Just to answer your question.
Why even argue in the alternative? What's the basis to make the argument?
The reason is just for what the argument was made here today in court is that the argument that plaintiff keeps raising is not only the wrongful death cause of action, but the fact that prior to 2009, the Port Authority had an obligation to put in suicide fencing. And that squarely goes to our governmental immunity argument. So we had to argue both. And that has nothing to do with ordinary negligence standard of care, the duty to maintain the bridge in a reasonably safe condition. What Kevin Gorman did and what Lieutenant Duffy did in their affidavits is detailed every single step and effort the Port Authority had done to show that they maintained the bridge in a reasonably safe condition, and there was no obligation to prevent Mr. Donaldson from committing suicide because it had met the reasonableness standards for the railings.
Who makes the decision with respect to whether or not the steps taken by the Port Authority were reasonable? Is it us as the court in the first instance here, or is it a factual question for the jury?
It's not a factual question, Your Honor. The standard has been met that based upon the efforts that were made by the Port Authority.
So my first question to you then is why didn't you close the bridge down? Why didn't you close the sidewalk?
We absolutely could not do that, Your Honor. There are mandates that there be public access to the pedestrian walkways, and there are many groups that protest any closings of those
Did the Gorman affidavit or the police affidavit address that, or any other something inside your motions for the support for your motion for summary judgment?
No, Your Honor, because that doesn't go to the heart of an ordinary negligence standard. Closing the walkway, again, is a governmental decision, and the fact is whether or not the walkways in and of themselves were reasonably maintained.
Respectfully, I think you go back to this, but I think that you need to read Feldman 1 again. You're acting in your proprietary function. That's what we found, and you try to get away from it, and that's the law now. So only the Court of Appeals will ultimately decide whether it's correct or not.
No, and we understand that, Your Honor, and that's why we retained Kevin Gorman so that he could determine whether or not the steps that were done by the Port Authority were reasonable under ordinary negligence standard of care.
So your position is that under ordinary negligence, you've met your prima facie burden, and the plaintiff hasn't put in anything to raise a tribal issue of fact?
Yes, there's not a single shred of evidence that the plaintiff put in to refute that, and they had ample notice to do so. We served our disclosure prior to filing our motion for summary judgment. They could have retained an expert in opposition to our motion for summary judgment, which they did not do. They simply put in a few news articles saying that there were multiple suicides at the George Washington Bridge, and that was their argument as to why summary judgment should be denied.
Thank you.
Thank you, Your Honor.
Even from the Gorman.
Why didn't the plaintiff retain an expert? You argued that you had no idea, but now we've been notified that there were expert disclosures exchanged. Why didn't the plaintiff, in response to defendant hiring an expert, hire its own expert to rebut any showing made by the defendant's expert?
I think the disclosure came the day before the motion. I'm drawing on memory right now.
Did you ask for an adjournment of the motion so that you could retain an expert?
Yes.
Or oppose it on the ground that you needed more time to get an expert?
Well, we did oppose it on the grounds that we needed discovery because discovery was far from complete. Indeed, the Port Authority had stipulated
But did
that
you
there was
make the
going to be more
specific
discovery.
argument that you needed time to retain an expert to oppose the motion?
Not specifically about an expert. We did find in Gorman's affidavit enough reason to deny summary judgment.
You were going to rely on the argument that their affidavits were insufficient as a matter of law to make their case, and you didn't need to rebut it. I mean, was that?
Yes, insufficient because it fails to account for the delays in taking the steps that they took.
But wouldn't you need support for that other than an attorney's affirmation? You would need somebody to support that, to say that it was unreasonable. Otherwise, all we have is an expert on their side saying that it is reasonable. We took these steps. This is why it's reasonable because of the wind. We have to close one side, another side. You had it all laid out there. How does an attorney's affirmation, how is that sufficient to oppose that?
The deficiencies emerge from his own affirmation, so his own affidavit.
I mean, we've had other cases where, there's been situations where plaintiffs or defendants of whoever's on the opposing side of the summary judgment motion, point to deficiencies, and that's not enough because you have to at some point make more affirmative steps to establish your position.
Well, if Your Honor, please, the delinquencies or the failures on the part of the Port Authority that Mr. Gorman proves for us are that they did not even think about a temporary fence until late 2016. People were dying every year, a dozen, 20, 18, like that we know of.
So you didn't think you needed an expert? Okay,
Thank you, Your Honor.
Any more questions? Thank you very much. SR versus Erle.
Good afternoon. May it please the court, Gary Dwyer for the defendant appellant, Dr. Erle. It's appeal from two orders that denied the defense physical exam. And the chronology as outlined in our briefs indicates that, there was COVID death of the client, but more importantly, there were a series of failures of discovery to provide any authorizations or updated records for the dermatological care. This is a medical malpractice case.
Just to be clear in the argument, there are two different requests for IME. There's the initial request and then the subsequent request after you got further information. Are you now addressing the second request, just to be clear for the argument?
No, actually, I was just giving the chronology because it's really, this court has to look at the fact that there was a physical exam done by the plaintiff's expert in July of 2023, which was way before, months before, the motion was made to appoint an administrator, wherein at that conference, the judge raised discovery issues and said, you waived the physical exam. The defense didn't learn about that physical examination until an expert disclosure was served in February of 2024, which was several months later after the initial order was given that said the defendant waived the physical but could get additional
so why, for the
records.
second, let's focus on the second request for an IME, which was the renewal motion. What's your argument as to why at that point you should have been given an IME after the subsequent disclosure?
Yes, Your Honor. Under the uniform rules, we outlined the uniform rule 202.17 with the subdivision, I think it's B, says that the defendants have the right to get the plaintiff's report of a physical examination within 20 days before conducting their own physical exam and to get appropriate authorizations for hospital and other records for the defendant. The whole theory of that is for the defendant to be able to evaluate.
Did plaintiff identify new conditions subsequently that you say you need an IME for?
Well, what the plaintiff did was the plaintiff got a report of their expert which outlined the findings and which was not served, was not disclosed or served during the pendency of all this until after the defendant was deemed to have waived the physical examinations. And this court a few years ago in the Drame versus Ambulate PRN case, which was actually my case that I argued before this court, 137 AD 3D 631, medical reports were served, the case was on the calendar, and this court held it was an improvident exercise of discretion for the IES judge to deny the defense a further exam and a new exam based upon the service of a report and a further exam. Here, the plaintiff's counsel never gave the authorizations necessary to evaluate the dermatological condition completely to do the exam until February of 2024. And most importantly, they have now had an exam that was not disclosed during the course of all this. The only way it was found out was in the expert disclosure, which was, I think, at page, in the record, I think it was page 221 of the record. There was an expert disclosure made in February, after the initial order of January was issued and before the next order reiterating a waiver of the physical, where it was indicated the expert will rely upon records and the examination of the plaintiff. And now the plaintiff got a report, served it, and where's the defense at? You can't get a physical? This court has held that the uniform rules.
Any evidence that the plaintiff would be prejudiced by not submitting to a further IME?
Absolutely not, because it's not a further. It's
An IME, yeah.
And for the defendant not to have a physical, for the plaintiff to do this, have no disclosure, and have their examining doctor, their expert in July of 2023, examine the patient. Because this court has also held cases where even if an expert examining physician, who's even not a treating physician, does that, a report has to be issued, whether or not that doctors are going to be called to trial. But here it's even more evident because that doctor is going to be called to trial as their expert. So the defendant here is in a position where it's extreme prejudice, that the plaintiff, after the fact, did all this, and we don't have a physical exam to rebut that, to review their findings.
Thank you.
May it please the court. This is Ted Triefanol, the respondent. Judge Capella's order required the physical exam, the IME, to be held within a certain period of time.
Focus on the second request for an IME and the renewal motion. Assuming that the judge was correct for purposes of the argument that the initial request for an IME was appropriately denied, what about the second request after there had been an examination by an expert and further information provided?
It's a very good question, but the answer to the question was, we consented. What is peculiar about this case...
What, you consented to the IME when it
we consented to it. What's peculiar about this case...
Why didn't it happen if you consented?
Because it's not about having an IME, it's about delay. We said, and which is interesting...
Why did the court deny it? I'm sorry, we have a court order denying it, that's why you're here on appeal, because the court denied the second request, the renewal motion.
Sure.
So why was a motion even necessary if you were consenting to it? I'm a little confused.
That is a good question.
Well, where in the record does it show that you consented to it?
They admit that we consented to it in the record. In their brief, I cited in my brief, I don't have the page in front of me, but they admit that we offered to have an IME.
Why let the IME happen now and then it's all good?
Well, this is our point. Our point was when they made a motion to strike our note of issue.
Oh, you consented to it as long as it stayed on the calendar. Now I'm remembering.
As long as it stayed on the calendar.
That's a proviso. They don't have to consent to it staying on the calendar. If they have a valid right to an IME before the case gets put on the note of issue, they don't have to consent to it staying on the calendar.
I think we ought to look and see what happened.
I mean, I often remember as a trial judge not letting that happen all the time.
Textually, we should put this in context. The PC order was in 2020. 2020. It required the IME within 20...
Counsel, can we just deal, I think that we're trying to focus your attention to the motion to renew and then the second order, because my concern is this, and maybe you can disabuse me of that concern, is that in your February 5th disclosure, You say for the first time that your client's been examined by an expert, that that you also disclose previously undisclosed counseling and other kinds of medical care. So based on that, isn't that a change of circumstances upon which renewal should be granted?
No. The IME, the report that was issued by the expert was the same expert who issued the certification for the medical malpractice action. It wasn't somebody new. They requested, the defendants requested the report from the examining physician.
Did you disclose additional treatment?
No.
So it's the same identical report?
It's all identical. There is no new treatment. The stria is permanent.
Had the expert examined her before it issued its report to support the medical malpractice claim?
Yes. Yes. This is the same expert who supported the medical malpractice action. And what's troubling to me...
So absolutely no new information was disclosed?
No new information was disclosed. And there's nothing new about the stria. It's permanent.
Was there new information about counseling or dermatological care that wasn't disclosed before?
The dermatological care came way after the period of time in which the IME should have been held.
Right, but wasn't that in fact new information?
No.
Okay.
She went to a single visit to a dermatologist years after the exam should have been held, and we disclosed that. But I'd like to make one point, though, to put this in context. There were 5 series of requests for authorizations that were made. Of those 5 series, they were on November 24th, 2020, January 2021, May 13th, 2021, May 17th, 2022, January 30th, 2024. 12 of the 23 requests that were made in those periods of time were duplicates or triplicates of those. 8 were duplicates, 4 were triplicates.
Thank you. Thank you. Your time's up.
I just wanted to make one point that the offer that was made, it's in the record, was based upon not, as Justice said, not moving to strike the note of issue, but in addition, not moving for summary judgment and not getting the additional.
I want to get back to the idea of renewal as to whether or not renewal should have been granted. And renewal, as you know, can be granted if there are new facts. Were there new facts alleged that would be a basis to say that the motion to renew will be granted? Your adversary says absolutely not.
Yes, Your Honor, on several bases. One, from the records that came in that were outstanding, that authorizations that were served in February of 2024, which is after the original order, but more importantly, the fact that there was an exam done the year before, a report of which we would definitely get under the established law by this court. So that's the new circumstance, which has been served, by the way.
Was there additional care alleged in the May report by plaintiff?
In the May report?
I'm sorry, the February report.
The February was the expert disclosure.
Was
March
additional...
was the physical report. I'm sorry, Your Honor, but
that's okay.
It's gone. Okay, thank you.
Thank you.
Thank you.
Malkowitz versus Acquisition America.
Good afternoon. If it please the court, Paul Gruber, Bora Goldstein, Schuler, Naines, and Goydell for the appellant defendant. We believe summary judgment was improperly denied in this case. It's clear that there was a rent control department until 2008, and that the landlord, as was its right under the rent stabilization law at that time, when the rent control tenant vacated, negotiated a rent with the incoming tenant, which brought it over the luxury deregulation threshold.
Counsel, wasn't there a number of suspicious circumstances around the first rent after the rent control vacancy that at least raise an issue of fact as to whether the high rent destabilization of the apartment was actual, legal, and legitimate? Hasn't there been enough raised in terms of specific things to at least let it go forward and not grant summary?
I don't believe so, Your Honor. First of all, we disclose in our papers that the rent control tenant vacated in accordance with the agreement pursuant to the landlord. Under the Court of Appeals Authority, a matter Matinzi versus Joy, and this court's decision in Murrow West versus Prager, that is something a rent control tenant could do. It's not considered a waiver of rights, and I don't believe the court.
But let's talk about some of the circumstances, because the first tenant that went in was over the $2,000 at the time.
Yes.
Then that rent was never, ever achieved again. That tenant stayed 1 year, and then every other rent since then was lower than the $2,000 up to the current day. There's never again been a $2,000 rent charged for that apartment. And the rent control tenant who vacated was given a $20,000 payment in 2008, which would support that there was some intent on the part of the landlord to figure out a way to deregulate. Aren't all of those circumstances at least enough to raise an
Absolutely
issue?
not, Your Honor. I don't believe so, because under the various incarnations in the rent regulation, the luxury deregulation statutes beforehand, once you've hit the threshold, the apartment was deregulated, and if because of a market condition or even the whim of the landlord, you wanted to charge something less than the deregulation threshold, that did not change the deregulated status of the apartment.
Well, your argument, I think, your primary argument is that this action is time barred, correct?
Yes, it's.
So let's talk about that. Aren't there cases, Thurman, for example, which say that you're not time barred from challenging the rent stabilization status of the apartment?
Well, Thurman, that's what the law is.
Well, that's what Thurman says, right?
You can debate the wisdom of that.
I agree. But that's what our predecessors said.
Exactly. Thurman's a different case. That was a pre-answer motion to dismiss. This is a motion for summary judgment.
Right, but Thurman brings up the issue that certainly holds that when you're challenging whether or not an apartment is in fact properly destabilized, there's no real statute of limitations. You can go back in time to make that challenge. So why can't the plaintiffs in this case make the challenge that first lease, which is what caused it to become taken out of rent stabilization, was not a legitimate lease, and therefore there's no time bar to this action because it's a challenge to the rent stabilization or destabilization?
Because, as I noted before, that was a deal that the rent control tenant could make because it did not waive any right of.
No, I'm not talking about the rent decon. I'm talking about the first tenant afterwards who went in for a lease. I mean, the lease that got this apartment out of the rent stabilization process was the very first lease after the rent control tenant left.
At $21.25 a month, yes.
Right, so that's the question. Can't they present evidence or get a trial on the issue of whether that really was a legitimate and real lease? And haven't they raised enough issues or suspicious circumstances which should let that issue go forward?
No, the only thing that we have in this record is an affirmation of counsel which went to technical issues concerning the admissibility of the documents, all of which were clarified.
Well, don't we have a little bit more than that? We have the fact that after that, there were two other leases, the one that's which is the subject of this litigation, that the rent was then reduced. In addition, we have, there were no filings on the deregulated apartment that's a little bit more than just simple affirmation.
Can I answer the question, Your Honor?
You certainly can.
Absolutely. Thank you. The absence of the RR1, which I think you're alluding to, only meant that the tenant had 4 years instead of 90 days to challenge the initial rent for the apartment after the termination of rent.
So you're talking about a fair market rent appeal. That's not what we have before us. Thurman made it very clear that what we're talking about here is different than a fair market.
Yes,
entry
exactly. And here we are now. We're making a motion for summary we made a motion for summary judgment, and I know I'm over my time. We made a motion for summary judgment. We laid bare our proof. They did not say that they needed X, Y, and Z in order
Okay,
to.
let's hear from them and hear why they think there is an issue of fact to go forward.
Thank you, Your Honors. May it please the Court. Himmelstein, McConnell, Gribben, and Joseph, LLP, for the respondent. So, Your Honor, the lower court's decision denying.
Counsel, let me ask you, assuming that we find that that lease is admissible and it's admissible evidence, why isn't that lease sufficient as a matter of law to find that this apartment was validly taken out of rent stabilization back when that lease was entered into?
Right,
Why
so-
should we doubt that lease, which, if we're assuming it's properly admitted?
All right, so if indeed this plays out in that way, and it is established at trial that that lease or that lease is valid, then the
Why do
argument.
we get to trial? Why? They've presented what appears to be a valid lease. It's for over the market. That would take it out of rent stabilization. Why do you have to lay bare your proof
We
now?
do have to lay bare.
So what's the proof you've laid bare, other than, that they never got that rent again, that was not a real lease?
Right, so we do a couple different things, Your Honor. So one, we question, we also say potentially the lease shouldn't be sufficient to establish that there was a tenant in occupancy paying above the threshold. And we question also their payment records.
Well, that's what I was going to ask you.
Yes,
Were checks submitted, payments submitted with respect to, now I'm talking about the initial lease that took it over the luxury decontrolled threshold?
in support of their motion for summary judgment, they submitted what purports to be a rent ledger, but there's no further proof, right? And we speak about that in our papers, how that.
Assuming they made a prima facie based on the testimony of the manager that these rent payments were made, how have you, in opposition, raised any issue of fact as to whether or not these rental payments were or were not in fact made, or that this lease was not a valid lease when you deregulated the apartment?
Right, so a few different things. So first of all, we've talked about it, what's been talked about in the arguments, this is not an RR1, this is not a fair market rent appeal.
I'm assuming that for purposes of my question to you. I'm assuming that the only issue before us is whether that was a valid lease.
There's whether that's a valid lease, right, meaning that the tenant actually occupied the apartment and paid the rent.
Enough to take it out of rent stabilization.
If indeed the apartment was right, if they could connect those dots, and the law is the law. I mean, if an apartment is subject to rent
Right, so
control.
how did you raise an issue? I still haven't heard your answer. I would love to hear. What is the issue of fact as to whether or not that was or was not a valid lease?
They just did not sustain that burden on their motion to.
So you're not arguing you raised an issue of fact in opposition. Your only argument is that they didn't make a prima facie?
That's correct. They did not make out.
And you don't even want to
prima facie.
argue that you've raised issues of fact in opposition?
We did raise the issues of fact in
So
opposition.
that's what I'm trying to ask you about.
Right, and I think, Your Honor, though, your question, though, is that if indeed the lease is valid, right? And I think that's.
No, if they made a prima facie showing, what issues do you raise in opposition? I'm sorry, I don't know how else to ask
It's not a
you.
trick question.
It's not a trick question. No, but I mean.
So you're not answering
You
it.
just said that you raised issues of fact. What are they?
Oh, so that whether or not the lease was actually signed by the owner, whether or not this tenant was actually in occupancy, whether this tenant actually paid, we submit a whole bunch of documents from ACRA showing the signature of the owner, comparing that to the signature on the lease. Those are the issues of fact that we raise in opposition.
Thank you.
Thank you.
As for the issues with respect to the signature, we address those completely and thoroughly in the reply affirmations and affidavits, which is an appropriate thing to do on a motion for summary judgment. As for the landlord's records about the payments,
You don't have an affidavit by anyone who actually swears that they were present when the tenant signed it, right?
Your Honor, that was a very long time ago. These cases should
Well,
be
you're still
decided by
employing the
by the rent history. We should not be imposing impossible burdens at this point on anyone. Mr. Shalom, I think, verified that there was his signature or that of his agent on in his
If he
employ.
still works for you and could verify his own signature, he could have also verified the circumstances of the signing of the lease.
Well, maybe he doesn't know the circumstances, but what I'm saying is we shouldn't make the burden here impossible so that these cases go on forever. We have documented a full rent history. The affidavits of Mr. Blum attest to that the rent ledgers are records maintained in the ordinary course of the owners and the agent's business. I don't know what more we could produce here to prove the case here, and I know we got nothing in opposition.
Yeah, can you just, it's okay. What about the $20,000 payment on top of some of the other issues that council has raised?
Again, Your Honor, we have speculation that was improper. However, as I stated in my main argument, a rent control tenant can give up their rights to possession. She was free to make that deal, and this court has held that doesn't waive any rights. Unless there are any further questions, happy Thanksgiving.
Happy Thanksgiving.
Thank you. You too.